नमस्कार। इंडिया डिबेट में आप सबका स्वागत है। मैं हूं आशुतोष पाठक। आज रविवार है, आप छुट्टी मना रहे होंगे, लेकिन हम आपके लिए आज एक ऐसा वीडियो लेके आए हैं जिसमें आप लाइव देखेंगे कि कैसे जस्टिस सूर्यकांत ने वकीलों की पूरी दलील सुनी है। और ये वीडियो आज मैं आपको संपूर्ण रूप से दिखा रहा हूं। मैं फ्रेम से हट जाऊंगा, पूरा वीडियो तफसील से आप देखेंगे। वकीलों ने क्या दलील दी है, सीजीआई ने उस पर क्या कहा है, जो रिपोर्टिंग हुई है उसका क्या माजरा है। और जब ये वीडियो आप पूरी तरह से देख लेंगे, फिर मैं आपको कल उन्नाव रेप केस से संबंधित बहुत सारे डिटेल आपके सामने रखने वाला हूं। ना काहू से दोस्ती, ना काहू से बैर। जहां जस्टिस कॉम्प्रोमाइज हो रहा हो, जहां सत्य कॉम्प्रोमाइज हो रहा हो, वहां तहकीकात करने की आवश्यकता है। सत्य किस तरफ कॉम्प्रोमाइज हो रहा है? क्या पीड़िता के साथ हो रहा है या जो आरोपी है उसके साथ हो रहा है? ये देखना बहुत जरूरी है। हम उस तरह की पत्रकारिता नहीं करते जहां कोई एजेंडा चलाने की बात हो। हमारी कोई एजेंडा नहीं है। हम किसी एजेंडा में यकीन नहीं करते हैं। आपको मालूम है, पिछले 2.5-3 वर्षों से जिस तरह से दिशा और सुशांत के केस को हम फॉलो कर रहे हैं, हमारा कोई एजेंडा नहीं है। किसी के साथ हमारी कोई दुश्मनी नहीं है। हम सिर्फ और सिर्फ न्याय की लड़ाई लड़ रहे हैं, सत्य की लड़ाई लड़ रहे हैं। मैं ये बिल्कुल नहीं कह रहा हूं कि कुलदीप सिंह सेंगर बहुत निर्दोष है, लेकिन कुलदीप सिंह सेंगर की बेटी जो कह रही है उसको भी ध्यान में रखना पड़ेगा, सुनना पड़ेगा, जांच करनी पड़ेगी। अभी तक जो मीडिया में खबरें चल रही हैं उसके हिसाब से कुलदीप सिंह सेंगर बलात्कारी है, हिंसक है, बाहुबली है। लेकिन जो पर्दे के पीछे की बात सामने आई, आप याद कीजिए, जब दिशा की मृत्यु हुई थी तो मीडिया ने यही चलाया कि दिशा ने सुसाइड कर लिया। पूरी तरह से यह मामला गौण हो गया। अगर सुशांत का डेथ सामने नहीं आता तो दिशा का मामला प्रकाश में भी नहीं आता। मित्रों, आप इससे कल्पना कीजिए, अगर सुशांत की मृत्यु 13-14 जून को नहीं होती तो शायद दिशा का मामला प्रकाश में भी नहीं आता। दिशा मीडिया की सुर्खियां भी नहीं बनती। सिर्फ एक रिपोर्ट छप गई और पूरी मीडिया ने उसको चला दी होती, या चल गई होती, या चली भी, कि दिशा नाम की एक लड़की थी जिन्होंने सुसाइड कर लिया और वो अपने दोस्तों के साथ पार्टी कर रही थी और वो डिप्रेशन में थी। कोविड का दौर चल रहा था और इसलिए उसने 12वें 14वें फ्लोर से छलांग लगा दी और वो मर गई। मुंबई पुलिस ने इन्वेस्टिगेशन कर लिया, मालवनी पुलिस स्टेशन ने इन्वेस्टिगेशन कर लिया। इन्वेस्टिगेशन के बाद सारी तथ्य सामने आ गए। एसीपी ने मैटर को क्लोज कर दिया क्योंकि मुंबई पुलिस ने उसे एक्सीडेंटल डेथ माना और बाकी लोगों ने कहा कि वो सुसाइड हो गया, लेकिन मुंबई पुलिस ने उसे एक्सीडेंटल डेथ माना। सुसाइड हो गया, नहीं हुआ, क्यों किया, नहीं किया, इसकी तहकीकात मुंबई पुलिस ने नहीं की। मुंबई पुलिस को सिर्फ यही वर्जन मिला रोहन रॉय एंड उसके साथियों की तरफ से कि दिशा डिप्रेशन की शिकार थी, दिशा परेशान थी, दिशा हाथी ने कुछ क्रैकर्स खा लिए थे, विस्फोटक खा लिया था, उससे एक हथनी की मौत हो गई थी, उससे दिशा परेशान थी क्योंकि दिशा तो जानवरों की जानवरों को बहुत प्यार करती थी दिशा। एक से एक स्टोरी बनी और दिशा के केस को पूरी तरह से क्लोज कर दिया और दिशा के परिवार वाले, पिता और माता, चुपचाप शांति से सुनते रहे, बर्दाश्त करते रहे। लेकिन जब क्यूबाइव नेटवर्क ने उस मुद्दे को खंगालना शुरू किया, देखना शुरू किया, पहले से ही इस बात पर कोई क्यूबाइव नेटवर्क पूरी तरह से मुतमईन थी कि ये आत्महत्या नहीं है, ये मर्डर है, इसकी तहकीकात होनी चाहिए। अब अगर है या नहीं है, बस इसकी जांच की लड़ाई क्यूबाइव नेटवर्क लड़ रही है। मुझे ऐसा लगा या हमारे नेटवर्क को लगा या हमारे बहुत सारे लोगों को लगा कि दिशा की सुसाइड नहीं हो सकती है, दिशा आत्महत्या नहीं कर सकती है, दिशा क्या मर्डर भी हो सकता है, इसकी जांच होनी चाहिए। और फिर हमने जब इसके सबूत इकट्ठा करने शुरू किए तो मामला बिल्कुल पलट गया, मामला बिल्कुल अलग हो गया। और इस प्रकार से ये सुई इस तरफ जाने लगी कि हां वाकई में दिशा की हत्या की गई है। और अब तो और भी ये सबूत बिल्कुल आ गए, क्योंकि पुलिस लगातार इस मामले को लिंगर ऑन कर रही है, तो इसके बारे में जांच ही नहीं करना चाहती, एफआईआर नहीं करना चाहती। अगर पुलिस की जांच सही है तो पुलिस कहती कि ठीक है, दिशा के पिता ने कंप्लेन किया है, हम एक बार दोबारा जांच कर लेते हैं, इनकी संतुष्टि हो जाएगी। पहले हालांकि दिशा के पिता ने कहा था कि भाई नहीं नहीं, हमें किसी के ऊपर शक नहीं है, लेकिन अब पता नहीं फिर इनको लग रहा है कि नहीं, हमारे बेटी की हत्या हुई है तो हम जांच कर लेते हैं। क्या जाता है, ये कानून का विषय है, इसमें इतना विलंब क्यों हो रहा है? अगर वही वो एक बार, ठीक है, आप कह सकते हैं कि बार-बार वो अपना स्टेटमेंट बदल रहे हैं। हाँ, बिल्कुल बदल रहे हैं। उन्होंने कहा है कि मैं पिछले सरकार के दबाव में था, डर में था। डर की वजह से मैं चुप था। मेरे पास सबूत हैं, और फिर वो सबूत लेकर के बाहर आए, और फिर वो सबूत जब दुनिया के सामने आई, तो ज़रूर ज़ाहिर है कि इसकी तहकीकात होनी चाहिए, जाँच होनी चाहिए, मामला इस तरह से आगे बढ़ रहा है। ठीक उसी प्रकार से उन्नाव रेप केस को जब मैंने देखना शुरू किया, बाकी लोग तो देख ही रहे हैं जिस तरह से देख रहे हैं, मैंने देखना शुरू किया तो मुझे कुछ तथ्य मेरे सामने आए। उन तथ्यों को भी मैं आपके सामने रखूंगा, लेकिन आज पूरी कार्रवाई आप अदालत की पहले सुन लीजिए, सुप्रीम कोर्ट की पूरी कार्रवाई सुन लीजिए। अंग्रेजी में है ये पूरी कार्रवाई, और आपको देखनी चाहिए, आपको सुननी चाहिए। यहां से मामला आगे बढ़ेगा। सीबीआई के वकील ने जो दलील दी है उसमें पुष्टि हो गई है कि कुलदीप सिंह सेंगर ने बलात्कार किया है, लेकिन कुलदीप सिंह सेंगर के पक्ष में बहुत सारी बातें आ रही हैं। उसे उसकी तहकीकात करना बहुत जरूरी है। पीड़िता के परिजन के मामले में, पीड़िता के पूरे परिवार के मामले में, पीड़िता के पिता सहित 2 चाचा, तीनों चाचा के बारे में कि वो अपराधी रहे हैं, उनके खिलाफ 17-17 मुकदमे हैं, 20-20 मुकदमे हैं, और आज से नहीं 1993 से हैं। और उनके वो एक ही स्वजातीय हैं, वो कोई गरीब नहीं है, अच्छा खासा परिवार है, 7-7 करोड़ रुपए उनको मिले हैं, और ये पूरी राजनीतिक रंजिश है। तो क्या कुलदीप सेंगर को फंसाया गया है? और अगर फंसाया गया है तो ये साक्ष्य क्या कहता है, सत्य क्या कहता है? इसकी जांच जरूर होनी चाहिए। और अगर कुलदीप सेंगर ने बलात्कार किया है तो कठोर से कठोर सजा होनी चाहिए। हमारा पक्ष बिल्कुल स्पष्ट है, ना काहू से दोस्ती, ना काहू से बैर। लेकिन मीडिया ट्रायल को एक बार फिर से चुनौती देना पड़ेगा, और बहुत धैर्य के साथ। मैं समझता हूं हमारे बहुत सारे दर्शकों ने पिछले शो पे मुझे प्रतिक्रिया भेजी थी कि आशुतोष जी, ये बलात्कारी है, आप उनके समर्थन में। बिल्कुल नहीं, मैं समर्थन में खड़ा नहीं हो रहा हूं, लेकिन कुछ तथ्य सामने आ रहे हैं। जिस प्रकार से पुलिस ने कह दिया था दिशा के मामले में, और तथ्य जब सामने आए तो क्यूबाइव सामने आई, और फिर आपको भी लगने लगा कि हाँ, ये हत्या है। ठीक उसी प्रकार से इसमें ऐसे चौंकाने वाले तथ्य आए हैं मित्रों, जो अकाट्य हैं। आप कल्पना कर सकते हैं, एक तरफ आदित्य ठाकरे अदालत नहीं आ रहा है, भाग रहा है, फरार हो रहा है, गलत एफिडेविट दे रहा है। एक तरफ कुलदीप सेंगर कह रहा है सीबीआई को कि मेरा नार्को टेस्ट करा लो। अद्भुत बात है ना? एक बलात्कारी कह रहा है कि मेरा नार्को टेस्ट होना चाहिए, और जो पीड़िता हैं, उनको जब कहा जा रहा है कि आपका नार्को टेस्ट होना चाहिए, तो वो नार्को टेस्ट के लिए तैयार नहीं है। संदेह तो उठता है ना? उठेगा कि नहीं उठेगा? तो थोड़ा ठंडे दिमाग से सोचना शुरू कीजिए, और इसलिए मैंने सुप्रीम कोर्ट की कार्रवाई आपको दिखाने का सोचा है। थोड़ा-सा ठंडे दिमाग से सोचना है आपको। जोश में होश नहीं खोना है। बस एक नैरेटिव को लेकर के आगे नहीं चलना है। ये नैरेटिव वॉर चल रहा है। ये मीडिया का वॉर चल रहा है। तो अगर एक बलात्कार का आरोपी कह रहा है कि मेरा नार्को टेस्ट कीजिए, पता चलेगा। सीबीआई को ऑफर कर रहा है, खुद आरोपी कह रहा है, और जो पीड़िता हैं वो, उनको जब कहा जा रहा है तो वो करने के लिए तैयार नहीं है। पूरा गांव, कोई दबंगियत की वजह से नहीं, पूरा गांव, पूरे गांव का एक एक वीडियो अभी सामने आ रहा है। बच्चा बूढ़ा सबके सब कह रहे हैं कि कुलदीप सेंगर को फंसाया गया है। और एक जगह तो मैं वीडियो देख रहा था कि गांव वाले कह रहे हैं कि हवा में गांठ नहीं लगती, सुना था, लेकिन कुलदीप सेंगर को जिस तरह से फंसाया गया, ऐसा लगता है कि हवा में गांठ अब लगने लगी है। इस तरह की बातें हो रही हैं। तो बहुत सारे प्रमाण आ रहे हैं जो कुलदीप सेंगर की बेटी दे रही हैं, उनके भी पक्ष को सुनना पड़ेगा। कुलदीप सेंगर का उसके पहले का इस तरह का कोई रिकॉर्ड नहीं है। ये बात जरूर है कि वो विभिन्न पार्टियों में रहे हैं, विभिन्न पार्टियों में तो बहुत सारे नेता रहे हैं, ये कोई आधार नहीं हो सकता। लेकिन अब कुलदीप सेंगर बलात्कारी है या नहीं है, ये साक्ष्य तो जुटाने पड़ेंगे ना। अब आप कहेंगे कि लोअर कोर्ट ने सजा दे दी थी। लोअर कोर्ट ने जो सजा दी है उसके लिए पेश किया जा रहा है पक्ष। नो वन किल्ड जेसिका का भी वर्डिक्ट आया था। अगर आप अदालत के वर्डिक्ट पर जाएंगे तो अदालत के वर्डिक्ट को भी चैलेंज किया गया है। नो वन किल्ड जेसिका का वर्डिक्ट आया था और हाईकोर्ट ने दिया था, इसी दिल्ली हाईकोर्ट ने दिया था। किसी ने जेसिका की हत्या नहीं की थी और सारे आरोपी बरी हो गए थे। लेकिन केस खुला, मुकदमा चला और मुकदमा चलने के बाद आरोपी जेल गए, तथ्य आए सामने में। तो सीबीआई एक तरफ तो कई बार दबाव में काम करती है, कई साक्ष्यों को इग्नोर करती है। जहां साक्ष्य लाने चाहिए वहां तो लाती नहीं है, और जहां नहीं है साक्ष्य वहां जबरदस्ती साक्ष्य जुटाती है। लड़की के पिताजी की जो हत्या की बात है, लड़की के पिताजी के ऊपर स्वयं 20-20 कह रहे हैं कि 10-10 20-20 मुकदमे रहे हैं। उनकी लड़ाई होती है किसी और से और पुलिस कस्टडी में उनकी मृत्यु होती है। ये आरोप जो इनके ऊपर लगा कि इनके कहने पर उन्होंने मारा है, नहीं मारा है, इसकी जांच होनी चाहिए। लेकिन बलात्कार हुआ है कि नहीं हुआ है, पीड़िता का बलात्कार शुभम सिंह और नरेश तिवारी, उनके ऊपर आरोप लगे हैं। एक यादव जी हैं, उनके हाथों बेचने की बात हुई है और पहले एफआईआर में कुलदीप सेंगर का नाम नहीं है। बाद में इनके भी खिलाफ इनके भी नाम को जोड़ा गया है। तो ऐसे कुछ तथ्य हैं जिस तथ्य की विवेचना बहुत जरूरी है। सीबीआई पर आप भरोसा नहीं कर सकते। सीबीआई क्या कर रही है सुशांत के केस में आप सब देख रहे हैं। मुंबई पुलिस दिशा के केस में क्या किया आप सब ने देखा है। इसलिए थोड़ा ठंडे दिमाग से मैं चाहूंगा आज की इस पूरी कार्रवाई को आप देखिए। मैं आपसे विदा ले रहा हूं, पूरी कार्रवाई देखिए और कल बहुत सारे साक्ष्यों के साथ हम आपके सामने आएंगे और फिर ये जो वर्डिक्ट चल रही है अदालत के बाहर हम अदालत लगाएंगे। तो आज पूरा ये लाइव वीडियो जस्टिस सूर्यकांत का आप देखिए। तो अब अभी पूरा लाइव वीडियो क्या हुआ सुप्रीम कोर्ट में, जस्टिस सीजेआई के साथ किस किस ने दलील दी, जो सीबीआई के वकील हैं उन्होंने दलील दी। लेकिन इस प्रकरण में एक आए हैं महमूद प्राचा आए हैं, उनको बहुत जबरदस्त फटकार लगी है सुप्रीम कोर्ट की तरफ से। लेकिन पूरा पहले वीडियो देखिए।
Framed during the trial on two broad offenses, section 376 of IPC and section 5 and 6 of the POCSO Act.
376 IPC
376 IPC
and
section 5C
5C of the POSCO Act,
within brackets
376(1).
Only a minute, sir. Sir, I'll say everything truthfully.
Hmm.
The charge is framed under 376. I'm, my lord, consciously making, my lord, my submissions, my lord. Now, when, my lord, the conviction is recorded, the conviction is on two counts. My lord, I can, my lord, just for easy reference, I have quoted, my lord, the relevant part of whatever I am, my lord, relying upon. This is, my lord, the order of conviction in para 3. Please have a look, my lords.
paragraph 3.
Paragraph 3 of this note. This is my note. What are the infirmities in the impugn order, my lords?
In view of the
This is, my lord, the trial court's conviction in view of the
course discussion.
in view of the aforesaid discussion, I find that prosecution CBI has been able to prove the guilt of accused Kuldeep Singh so-and-so beyond a reasonable doubt, and therefore he is convicted under section 376 IPC, please mark this, and section 5C and 6 of the POSCO Act. My lord, now I'm not touching, my lord, 4 because which I have said that there is a trial conducted, there is a finding recorded, that the child was less than 16. My lord, to be precise, 15 years, 10 months and 13 days as my lord held by the trial court's order, and we will have to, my lord, as of date, go by what the trial court's factual finding is. My lord, the appeal is pending. Now, there is an order of conviction.
Against this conviction, appeal is pending.
Appeal is pending, my lords. So right now, my lord, so far as the child,
Adding to your assistance,
yes,
page number 211,
yes,
when the sentence was pronounced, para number 13 and para number 14,
yes, I'm grateful.
where 376 to I has been dealt with.
Correct. I'm grateful, my lord. I'm relying upon it, my lords. My lord, kindly see, then, my lord, page 2, para 5. I'm grateful, my lord. At the time of sentencing on 20th December, the trial court convicted the accused under section 376(2) of IPC in light of section 376(2)I, which was undisputably on the statute book on the date of the offense. Now, my lord, what is that 376? My lord, before I take your lordship to this, my lord, 376 has two parts. 375 is definition of rape. He is convicted of rape. There is no doubt about it. 376(1) says that if you are convicted under 376(1), then the punishment would be minimum 10 years and maximum life. There is an aggravated form of rape. Lord, if someone who is in a dominant position,
There are 4 or 5 illustrations given.
illustrations,
Like in police station, suppose it happens.
a police station or someone who is a family member,
Or-
who has a dominant position,
Yes.
etc.
Or in an institution, public institution.
Public
it happens.
institution, my lord, orphanage, etc. Lord, then the punishment is minimum 20 years, and it can go up to your biological life. Lord, I, subsection 2, subclause I says, commits rape on a woman when she is under 16 years of age. Then dominance not necessary, nothing is necessary. If she is 16 years or less, then it would fall
And
under
independently, it falls within the mischief of 376 to I.
2I. And therefore, the punishment will be
20 years
minimum
minimum.
20 years and
or
maximum
can be
up to
life.
biological life.
That's it.
My lord, here the court, my lord, convicts him under 376 2I.
Assuming that the victim is not a minor, in a case where the victim is raped but not a minor, still the minimum sentence of 371 in any case will be there,
Will be up life.
will apply. That will be minimum 10 years. It can go up to 20 years.
Yes,
This
Right.
is also minimum
Yes.
10 years.
life.
2 is also minimum 10 years, not 20.
Two is minimum 10, but what is
To
awarded
that
is
extent, he is right.
Yeah.
You are right.
Yes.
To that
Yeah,
extent,
he's right.
To that extent, you are.
10 years.
the amended, he's right. As it stood then, now it is, my lord, amended that it should be minimum 20, but we are not concerned. Minimum 20 and it can go. Here, my lord, the court has said till your biological life.
Right, sir. The minimum point is the offense is committed on 4th of June 2017. This amendment has been brought subsequently
18,
on 21/4/2018.
18.
So on the date of commission of the offense, whatever the situation.
I was there.
I was there.
Yes,
All right, when the I was there on that day, then it will be read as it is, whatever the situation.
absolutely.
And when the suspension of sentence was directed, you directly come to the page. Come to the page number, para number 30.
Yes, my lord.
Come directly, we'll let you know this, brief it, everything.
My lord, page 215.
Yes. Then where they have only been dealt with, come to page number, internal page 37. Para 30, last line. They have dealt with of 376 2B without dealing with 376 2I. That is the crux of the matter.
Lord, as a matter of fact, your lordship comes to page 25, para 25 of the impugn order. My lord, please come to para 25 of the impugn order. My lord, that is more, my lord, erroneous. Page 30, my lord. Kindly, my lord, for my satisfaction, come to page, para 25, page 30.
Yes.
Para 25. The learned trial court has convicted the appellant for the offence under section 376(2) of IPC as well as section 5C punishable under section 6 of POCSO Act. For the purpose of present application, this court turns its focus to the appellant's conviction under the POCSO Act only. So 376,
No.
whether 1 or 2, It is life or biological life. That's the only distinction. But life is the minimum in the facts of the case. No, that's not considered.
Life
And the
is
court,
not the minimum.
only a minute, sir. And the court says, now 7 years, you are not a public servant. So you fall and, my lord, I have another argument, my lord, on POXO Act also, because my learned friend could argue on that.
Is it your argument that the concept of being a public servant
Yes,
is completely alien and irrelevant when the victim is a minor?
absolutely. Now kindly, my lord, take the POXO Act, where, my lord, there is a legal, what has gone wrong. My lord, please kindly have a look at, my lord, the POXO Act. My lord, POXO Act offences can be broadly classified in two categories. Broadly. One is penetrative sexual assault. It's per se an offence. My lord, section 3.
Section 3.
Section 3. Assault is an independent offence. Now 4 provides for the punishment. My lord, prior to the
Amendment.
amendment, my lord, which came after the offence was committed.
2019 amendment.
Yes, my lord, 2019, my lord, it was after the offence in, but my argument would be, it doesn't make any difference. I'll come to that. It was, my lord, not less than 10 years and which can be life. Earlier it was 7 years. Now, my lord, there is a separate category of offence. The same offence, my lord, which is penetrative sexual assault, but in certain circumstances, it is aggravated form. Aggravated based upon the person who commits the offence. And if you go by, my lord, the nocitera sociis doctrine or, my lord, the egestem generis, my lord, the categories are that if a person is in a dominant position over the victim, then he is considered to be an aggravated form of offence. Please have a look, my lord. Whoever being a police officer commits penetrative sexual assault on a child within the limits of police station, in premises of any station house, in the course of his duties or otherwise, or where he is known as or identified as a police officer. My lord, kindly take an example of 5A3. In the course of his duty, a constable is a category, my lord, who, if commits an offence, would be in the aggravated form. Kindly bear that in mind. Then B, whoever being a member of the armed forces or security forces commits penetrative sexual assault on a child, my lord, the same. But 3, in the course of his duty. So if an SRP man is there, my lord, in the security of a member of parliament or a member of legislative assembly, he would be guilty of aggravated penetrative sexual assault. Now please see C. Whoever being a public servant commits penetrative sexual assault on a child. My lord, my respectful submission is, my lord, public servant is not defined in this act. It is, my lord, defined as borrowing, my lord, or definition by reference, that whatever is defined under the IPC would be the definition. But the important question of law would be, section 2 starts with unless context otherwise requires. My lord, every word used in any statute is not mechanically getting the definition. If the contextualized definition is to be considered, then public servant would mean a person who is in such a dominant position over a child, because POXO, Lord, deals with only children.
So according to you, in the legislative intent, in a kind of a non-obstante clause in section 2 opening, where
Yes.
it says unless the context otherwise requires.
Yes.
The expression public servant is a very broader term.
Broader term.
Broader term. It's not necessarily for the purpose of public servant. Say you treat an PC Act or under
Or IPC.
IPC.
Yes.
Here, it public servant is that who is in a dominating position.
Yes.
In a particular factual background of a incident that is.
Particular case. In this case, he was MLA of that area, a very powerful MLA, and the girl
If a
was 15.
representative comes, if a public representative comes to MLA and seeks any kind of help, assistance for any, say, public duty, and there if he misuse that dominance of being a public representative, then this is your argument that such an act will fall within the ambit of
Public servant.
misconduct by the public servant.
Aggravated form of
Aggravated
otherwise.
form
No, otherwise, kindly see the incongruous position which arises. I am a member of parliament. My lord, I will have, my lord, one police constable as my security person. He would be a public servant for the purpose of, my lord, section 5. I will not be a public servant. Why? As per, my lord, the argument of the accused. Because in A.R. Antule case, the Supreme Court has said that member of Legislative Assembly is not a public servant. But that was in a fact-specific situation.
was in-
But what happened was, Mr. Antule was a chief minister when the offence was registered. So he was a public servant. Thereafter, he had to tender his resignation and therefore he ceased to be a chief minister but continued to be a member of Legislative Assembly. When the charges where cognizance was being taken, he raised an issue that this is a offence under Prevention of Corruption Act 1947, which did not have the definition of public
servant.
and therefore no cognizance can be taken against me
So
unless
there-
you have a sanction.
Exactly. So at that time, probably the member of the Legislative Assembly were not considered in public servant definition under
Yes.
the old act.
So the court, my lord, construed that provision in the context of Prevention of Corruption Act and against him that no, you may not be a public servant. You are MLA and therefore you need not have a consent sanction and you can be proceeded. That law will not apply if we interpret this public servant.
See the relevance of the context otherwise required. There the court did not want to grant him the protection of not being a public servant for the purpose of prosecution under the PCA.
Exactly, PC.
Therefore, court said,
Grateful.
even if you are not a public servant, you are still liable to be prosecuted.
I'm grateful, my lord.
So that was in that
Yes,
context.
yes, my lord. Now, my lord, my third submission. My lord, suppose he is not a public servant for the sake of argument, my lord. I presume he doesn't fall within 5C. He would definitely fall within 3. Because it is, my lord, it is a penetrative sexual assault. That is the finding recorded.
Minimum
Now-
7 to end life.
Yes.
Minimum 7 and life.
Now, my lord, 4. My lord, the argument is this, and kindly see, my lord, this is, my lord, the very nuanced argument which, my lord, I am placing for your lordship's consideration. When the offence was committed, penetrative sexual assault was an offence. I am on Article 20 argument. It was punishable by 7 years. Amendment does not create a new offence. It merely enhances the punishment. Instead of 7 years, now it is life. So when existence of an offence is not in dispute on the date on which the act under section 3 is committed, mere enhancement of sentence subsequently by the legislature would not fall foul of Article 20. There are judgments to that effect. You cannot have a new offence. The reason is this: when I am committing some act, but not any act, then I am presumed to know whether that act is illegal or legal. At the time when I commit that act, if that act is not an offence, then I cannot be punished. So new offence cannot be created retrospectively by the parliament or by the legislature.
Maybe that your argument probably it can be that there is an offence defined on a particular date when the incident takes place, occurrence takes place. That is, let us say in 2017.
Yes.
In 2019, when the amendment takes place, the amendment does not obliterate the offence. It does not erase the offence. The offence continues to be an offence.
Yes.
The legislature makes rather intention very clear that this offence we are treating very serious offence. It is an offence against the very ethos of the society, and therefore we are enhancing the sentence.
Yes.
We are enhancing the sentence. So when the court is examining, after somebody is held guilty, if he is found guilty, he is convicted.
Yes.
And when the question of sentencing comes, the court will see what is the growing trend. The growing trend is that the legislature wants it to be more harsher.
Harsher and
Want to send a kind of a very deterrent and a befitting response, keeping in view the very cruelty and the extreme ghastly.
gruesomeness of the offence.
The court, even under the old provision,
It was
when considering that whether it should be a case of minimum sentence or it should be more than minimum sentence.
But
So
another
sentencing part, it
the
can be.
logic behind Article 20 is, my lord, suppose I am committing an act today, any act, which is not a penal offence. I can say that, but I didn't know that this is an offence. Therefore, you cannot create a new offence. But when I am committing an act, it is an offense. Lord, can I say that I committed an act because I knew that it is only
It will
7
apply to
years?
reverse also. In a case, suppose there is an offence in 2017 and 19 legislature says it is no longer an offence.
Correct.
The court can keep in mind that he is guilty of a technical offence, which is today no longer an offence. Therefore, I should award him the minimum one.
That can be a consideration for sentencing.
Mitigating circumstance, one of the mitigating circumstances for the purpose of
Sentence.
evaluating the quantum of
Quantum
sentence.
of punishment. I am grateful, my lords.
That is probably what.
Yes, my lord. And the last, see, my lord, section 42A of the POCSO Act. My lord, this is also
Okay.
not considered. The trial court considers this. My lord, there is an intrinsic guidance as to what happens, my lord, if there is any divergence between any other law and POCSO. 42A. My lord, I am in the context of, my lord, IPC definition and this definition, and we have to state contextual meaning of public servant under section 5C of POCSO. Lord, please see, act not in derogation of any other law. The provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. And please mark, in case of any inconsistency, the provisions of this act shall have overriding effect on the provisions of any such law to the extent of inconsistency. Lord, fortunately, Lord, this convict, Lord, is also held guilty of, Lord, killing the father and some other people, Lord, in a different offense.
Where he has been
He is convicted
for part 2.
Yes, my lord. And he is still in jail, and therefore, Lord, in this impugned order, Lord, he has not been able to come out. So, my lord, this is an occasion where I would really, my lord, urge your lordship's conscience, my lord, to stay this order, my lord. We are answerable to the child, my lord, who was 15 years, 10 months.
Yes, what do you say, Mr. Harihan, Mr. Dave?
Now, my lord, can I? My friend, before my friend starts, your lordship may kindly see what was the charge.
What is your answer to para 25 and 26 of the High Court order, that where the High Court takes notice of the conviction under both IPC and POCSO, and then in para 26 the High Court inadvertently does not deal with the conviction under the IPC?
Just have 2 subsection 2 of POCSO for a moment. That has not been placed. 2 subsection 2. Please have that section.
Let us just read
2.
that for a moment.
There specifically it says, words and expressions used herein and not defined but defined in the Indian Penal Code, Code of Criminal Procedure.
No. Just a
No, no,
minute.
your lordship
Section
says-
2?
Section 2, subsection 2. 2. 2. After the definition, please see, it's not that there is a vacuum.
The words and expressions used herein
And not defined, but defined in
IPC,
the Code of Criminal Procedure, Juvenile Justice Act, and Information Technology Act shall have the meaning be respectively assigned to them in the said codes or the acts. So the High Court on Mr. Hariharan's argument, my lords, was that since IPC is specifically mentioned, 21 defines public servant. If 21 defines public servant, does not include MLA.
How does this subsection 2 answer the argument that when the conviction are two statutes, 2 different penal statutes,
Sentence is under
and the High Court only proceeds on the premise that sentence is under the POCSO only?
sentence.
No, lord.
Conviction.
Can I?
Not only sentence, conviction.
Conviction is under 2. You can't be sentenced under both, my lords, because of General Clauses Act, Section 25.
That's
you
right.
can only be sentenced under 1. Argument was, I'm sure my learned friend will be able to place it better than I can. The argument was that, look, you are sentencing whether I'm a public servant or not. The meaning under the POCSO is you have to take that meaning from the Indian Penal Code. Now, this argument that MLA is a public servant in the larger picture and all that argument for us doesn't arise for consideration here, because the statute itself provides that under 2.2 that the meaning will be taken from Indian Penal Code. And likewise, in Indian Penal Code, there is a section 7 which says words and expressions used herein at one place shall have the same meaning throughout the code. So it is too late in the day for my learned friend to contend that I am an MLA in the scheme that a public servant, and therefore, Mr. Hariharan argued that, lords, that this, when I can.
The matter would
My lord,
require
my lord, can I put 2-3 propositions before my lord?
No, it requires.
I was
consider.
consideration.
issue.
The first proposition, my lord, which I am making
You
is,
can argue on the point of stay. We are tentatively, we are inclined to stay the order.
your lordship will kindly see, I have 2-3 things to say on that. If your lordship will just hear me,
Before
is
he
not
starts
as if
on
I have been
sentencing,
debt-free.
he is as of
I
now,
have, my friend, can I?
no
You had-
sentence for life till you leave.
Can I have my say? This is,
General principle is that if someone has been released consequent upon an order of grant of bail, we will not stay that order without hearing the person, because we can't take away, we can grant bail ex parte, but we can't set aside that order. But here the situation is altogether peculiar. He continues to be in custody on account of his conviction and sentence in another case where he is still there in custody.
my lord, can I?
Appeal has been heard and 10 years out of 10, 9 years I've undergone.
I have gone under, your lordship, for a minute, can I?
Examine that part.
Can
We
I-
are not
can-
saying- We
can
are
I
only
make my
saying that
submission?
matter requires consideration.
Can I make my submission, my lord? In relation to 2 or 3 things, my lord, we will have to revisit the order passed by the concerned court. If your lordship sees that, the court was conscious all the while in relation to all the provisions.
So the
Number one.
order
No, it
Number
is
two.
very clear. Sir, Mr. Hariharan, this is
Please.
incorrect.
Please, my
The
lord.
court is not non-vigilant to look into all the provisions. We will kindly consider the court has only dealt with whether he was a public servant or not. The court has not dealt with whether the offence with respect to 2I or not, 376 2I.
Can I will,
Now, please
I will
kindly
answer.
tell us
I will answer.
where this has been considered.
I will answer, my lord.
Please
I will
answer.
answer. My first answer to this is that, my lord, the charges which were framed, the charges were framed under 376 clause 1. Your lordship will kindly see. I just show you that portion.
So this is not a ground of granting the suspension to you, sir.
That, my lord, I am saying that
This
there is
not
a
a ground
charge
to
which
grant
has
the
been
suspension to
framed
you.
in relation to 376(1). I was to answer that charge.
The ground of
He-
granting the suspension was, it doesn't fall within the definition of the public servant.
That is
And
the,
as per section 21.
as far as
And
public,
therefore, this has been done.
my lord, can I for a minute expound on that aspect also?
Yes, sir, please.
The element in relation to the public servant aspect is, my lord, the first proposition is a penal statute cannot import definitions from another statute in the absence of
Sir, we are
expressive.
going on that.
Unless the
Please kindly
penal
listen
statute,
for a
the
second,
the
sir.
law is, unless the penal statute expressly permits the borrowing of any such statement,
Yes.
Which it has
as
done.
it is done in the case of.
So here it is being done in relation to the Indian Penal Code, wherein the definition of public servant is to be imported from there. 21 does not give that scope.
Public servant, sir, public servant.
Your lordship will kindly see.
Mr. Hariharan, we crisp of everything. We are not dealing with their arguments at present.
Very good.
We are only saying it's a question of argument.
My lord,
Yes,
in
just
relation
please
to
listen.
that, in relation to
For a
that,
second,
my lord,
sir,
There are only-
kindly for a second, we are crisping everything. Come to page 211.
my lord,
Trial court's order, suspension.
211.
The sentence
Yes, sir,
report.
please.
13 is the submission.
13 and 14 is the submission, answer.
Yes.
Please
13
kindly
is the
see.
submission.
This is relating to 376 2I,
2I.
where the punishment has been directed. And now please tell us in the suspension order where they have dealt with of 376 2I. This is the answer.
Judge, please have 204 also at the same time. In the conviction order, please see what I'm convicted, under generally 376.
Two.
376.
376.
Please see
Yes.
204.
So 376 will cover 1 and 2 both.
Can't be
The
the
charge
law.
is
That
under
can
one.
go in on merit. No, you
The
can't ask
charge is
your.
under 1.
Sir,
Your lordship will
you
kindly
can't ask
see.
Mr. Dave. No, sir.
Your lordship
No,
are well aware,
sir.
it has to specify if there are two provisions providing for two separate.
How can it be that it will be a generalized situation, my lord? It's a,
Point is that there is a legal issue that requires determination. Maybe that your argument, we don't say, your argument has also a lot of weight. That also requires in-depth consideration. Sometimes to be very frank, the judges are one of the finest judges we have.
I look at what-
my lord, your lordship will kindly see that
Analytical mind.
there is a,
So far
is it
as
a media trial, my lord?
have been dealt with. There is a very in-depth analytical analysis made as far as of various provisions. But at the same time, we all are bound to commit errors. It's not
And that's all right.
That is besides.
That's all right, my lord.
But photographs of the judges being circulated.
examine. We are
My lord, there is one more important aspect to this. I have,
Mr. Hariharan, this aspect of definition of public servant in the context of POCSO
Yes.
is little bit
my lord, I will address in relation to that, as far as contexts are concerned, I will address, my lord. I have 14 propositions in relation to this, which I will place one by one. all constitutional provisions. And retrospectivity also. My friend is completely mistaken there because the retrospectivity aspect is that here what is happening is, my lord, a class of people are being.
We are only worried that a constable or a patwari, they will be public servant for the purpose of committing this offence, but a member of parliament or a legislative member of elected member of the state legislative assembly or legislative council, if this interpretation is construed to be correct, they will be exempted.
No, my lord, I will also deal with that proposition because here there will be issues which will arise in relation to doctrine of separation of powers as well. Because as far as those persons which my friend has defined, those persons fall within the.
Separation of powers is a
My friend.
constitutional doctrine,
No,
not in
can
the
I
penal state.
can I put across the, can I,
Prime Minister and
my lord,
Pew are saying-
can I make the proposition? Before that, my friend will take off. This is,
And we'll.
Manoj, kindly just a.
Issue.
my lord, there are only two things which I want your lordship to appreciate apart from this.
Issue notice returnable on so and so date. Issue notice returnable on so and so date.
For the victim.
It's all right.
Look, I am a aviator. Look, kindly, this is one half of the story. There,
Today we are not deciding the case.
look, I am only saying that I may be allowed to intervene in this matter. One,
We will see.
Milords,
Have you applied for?
yes, I am a caveator, Milords. I am a caveator in this.
Have you applied for? Why can't you file your own appeal?
All right, I will apply, grant me liberty. That is one, Milords. Kindly.
You don't
kindly
require
bear-
any permission, you have a right to file appeal.
Milords, can I hear
You will read
my lord?
provision of the CRPC.
2 minutes, Milords.
My lord, there is
Oh,
one,
that this is one half of the story. Milords,
Here you let
Milords,
the order go in
yes,
now.
my lord,
will
can
hear
I,
me.
my lord, can I just say one thing in relation to the stay? Only one thing, my lord, in relation to the stay.
We have heard briefly.
My lord,
At Solicitor of India at a considerable length in support of this special petition filed by CBI. We have also heard learned senior counsels representing the respondent in bracket accused,
Convict.
convict. We find that the subject matter that there are various substantial questions of law
yes.
which arise for consideration
Hmm.
in this special petition. Can say issue notice returnable on so and so date. Who is the lawyer on your side?
My lord, can I,
Sudhir, my lords, PS Sudhir.
The counter affidavit can be filed within 4 weeks.
my lord, I have a proposition to make if your lordship will hear me out.
We can't decide the
No,
proposal.
no, I'm not on that. I'm not on those propositions.
Now, we are.
I am making a submission, my lord. The submission is, my lord, if I am going to, in relation to the suspension part,
We are conscious of the fact that ordinarily, when a convict has been released on bail, a convict or stock under trial has been released on bail pursuant to an order passed by the trial court or the high court, such order shall not be stayed by this court.
Normally.
Normally.
We have.
We have said ordinary, will not be stayed by this court without hearing such person. Full stop. However, here are the peculiar facts and circumstances. Full stop. The respondent convict is also separately convicted and sentenced in a case under section 304 part 2, and we are informed by both sides that he is still in custody in that case. Full stop. Though he had applied for bail, and the order, and after hearing the arguments, the order is said to have been observed by the court.
one submission. Can I just make one submission?
Peculiar circumstances of the case, we stay operation of the impugned order dated 23rd December 2025, passed by the High Court. So consequently, the respondent shall not be released pursuant to the said, shall not be released from custody pursuant to the said order. Said order, full stop. Post the matter for so and so date.
Can I
Study.
now say something else?
Next paragraph. The victim, has a statutory right. Please remain silent. The victim has a statutory right to file a separate special petition. She does not require any liberty from this court. So in case she needs any free legal aid, the Supreme Court Legal Service Committee is directed to provide the free legal aid to her. However, she shall be, she may, if so advised, file her appeal to a counsel of her own choice also. In the other SLP जो साथ में simply adjourn to the Swansea Gate.
Lords, may I now say something, Lords?
Lord, there's-
May I
Thank you
now,
very much. Thank you.
Lord, I have only
may I
one.
now say something, Lord?
My Lord,
Thank you.
could
You
I-
have to argue outside also. You please go there.
Outside? The other side is arguing better than us.
Don't say
Outside.
I have outside.
We
We
only
have
have
not-
inside.
My Lord, we have that.
Lords, we only have inside, other side is arguing better on.
All right, item number 5.
Lords.
Next item.
My Lord, can I?
Let's kindly see a office report. In this case only, there is a suo motu proceeding which was going on. That got closed. Minutes, I am requesting that may be reinitiated once again. Because the entire country.
My Lord, item 4, in fact, has been filed by private persons.
Item
Now,
4 is not being
4 needs to be dismissed, my Lord.
4 needs.
There cannot be private persons making this into a PIL.
Passing any order, we will hear them only question of locus. Today we don't want to.
My Lord, they have converted an appeal into a PIL.
No, we have not converted anything. We are simply adjourning.
They are trying to do that, my Lord.
No question of adjourn. We will hear the only question.
And the other thing, my Lord, the one which is of concern, my Lord, one matter which is of concern, at least they should refrain from making statements against judges.
Judges, my lord.
They are doing that on television, national television.
Other side.
My friend,
Very unfortunate.
No,
Unfortunate.
this is,
I will show the other side is doing.
my Lord, this is totally bordering on contempt.
Lord's photographs of judges are circulated saying identify these judges. And remember they passing.
Can I show him, Lords, what they are saying?
We understand it's not, we are not
My Lord,
sitting
this
in
is-
ivory tower. We understand that people, they are trying to take political advantage. There are people who are trying to
Yes, my Lord.
take advantage.
All
That's
this.
It's
exactly
all,
the position. That's the
but
position.
we know nobody should really be bothered about it, and
But this
nobody
is
should
an
really take care of all.
This is an extreme.
They are saying.
But-
My Lord, there is a video circulating which says that the judges are corrupt and they have taken money. I can't believe this.
Saying on his gang.
Irresponsible,
Yes, Lord.
these irresponsible
Then
people are
Don't
forgetting
be irresponsible, sir.
that the
The
conviction was
recourse
by
is
the
permitted to
judiciary.
you and you want to take by moving an application, take a proper recourse, sir.
But the allegations which have been leveled.
So, all right, fine, whatever
File your
side is.
affidavit, we'll see.
The media, I never said anything against you.
Don't try to probate the system.
What is this convict saying?
You can't do
You are
this.
simply forgetting that he was convicted by judiciary only.
Yes, it
He was convicted under
So why is
304
the
only by
convict for
judiciary.
that?
No, I am talking about what is circulating in media.
Some erroneous order is passed, assuming erroneous order is
No,
passed.
I'm not
People
saying
take
that.
granted.
What is
You go to street
the
against the
convict
judiciary.
doing? What is the convict
Now
and
please
his gang
gang
is
court.
doing?
What
We don't have time to hear you.
Jail, what can I
Next
do?
item.
No, your gang.
What can I do?
Your gang.
One gang. My Lord,
Unnecessary.
kind
Member of parliament.
Go ahead to fight as you are doing, go outside, please.
That's what I'm saying.
No.
Why raising this issue here? Once again,
File your appeal, we will hear your appeal, we will
I am
entertain
raising-
the appeal immediately.
court to go. They have the
File the
entire.
appeal then. File the appeal if you have the court.
I am not
You
even
must
main
have faith in
party.
the system.
Look, is this fair? I was the main party in High Court also. I argued the entire matter.
It's all right.
I am not made a party here. Is this fair, my lords?
Why don't you file your
I
appeal?
will. I'm not saying that. But in a short notice, I come here without, I had to file Qvive after
There is no
Qvive. Then,
need for that. There is
no,
no-
but why are they making such a
You
huge?
have a
crime?
remedy
we
available.
are-
Avail of that.
They are convicts. They are making a hue and cry.
So a convict doesn't have a voice.
I am innocent. My father has been
So
killed.
like we have to hear other matters also. Item 5.
My father has been killed.
We argue
So what?
here, you argue elsewhere.
I have this court only to go. You have the
You
entire.
must come, you must come. Our doors are open 24 hours.
Yes, my lord.
We have said we will hear the matter even in midnight. How many times you want to?
We are
school
We are really grateful, your lordship,
We have all
took it
the
up.
right.
The
Learned
CBI
counsel,
this
learned
matter
counsel,
is
please just listen. We are humbly requesting you.
My lords.
Recourse is permissible to you. Take your recourse. And
Deeply obliged.
then don't make any referring remark. Yeah.
My lords. I
Please,
have not.
either to the side.
I have not.
They are making a
Please tell
submission.
them.
Please, they are making a submission to us, you make a submission to us.
making
You are not supposed to answer to their
I am
everything.
not asked.
No, sorry, please don't answer.
All right.
This is our humble request.
खूब-
Case inside the courtroom. Don't
खूब
argue
जमकर
outside. This is what we will
जमकर
advise you.
फटकार लगी महमूद प्राचा को, खूब जमकर फटकार लगी।
Next item.
और सुप्रीम कोर्ट में सीजीआई सूर्यकांत और दूसरे जस्टिस ने खूब फटकारा, कहा कि आपको जो कुछ भी कहना है आप कोर्ट में आकर के बोलिए, बाहर आप किसी जज के बारे में अनाप शनाप बोलेंगे ये ठीक नहीं है। और जो आर्गुमेंट कर रहे थे कुलदीप सेंगर की तरफ से, उनको कहा कि ये कन्विक्ट है, ये क्या बोलेंगे। तो उन्होंने कहा कि क्या कन्विक्ट को अपील करने का अधिकार नहीं है, बोलने का अधिकार नहीं है। इस तरह से बातें हो रही हैं। अब ये मामला 4 सप्ताह के लिए है। 4 सप्ताह मतलब 1 महीने के अंदर अभी कुलदीप सिंह सेंगर के वकील को अपने फैक्ट्स लेकर के आने हैं। मामला यहां पर आकर के रुक गया है कि वो पब्लिक सर्वेंट हैं या नहीं है। हाई कोर्ट ने कहा कि पब्लिक सर्वेंट नहीं है, इसलिए मामला एग्रीवेट नहीं करेगा, इसलिए उनके सस्पेंशन, उनकी जो सजा है उनको सस्पेंड किया है। लेकिन इसके आगे क्यूवाइव की एंट्री होती है। हमने क्यों इस मुद्दे को उठाया? हम ये उठा रहे हैं कि क्या कुलदीप सिंह सेंगर बलात्कारी है या नहीं है, इसकी सुनवाई कब होगी? अब इसकी सुनवाई कोर्ट में होगी और इसीलिए अभी जो हाई कोर्ट का जो डिसीजन था उसको अभी रोक करके सारे पक्षों को अपने पास सुप्रीम कोर्ट ने बुलाया है और कहा कि सबके पक्ष को हम ध्यान से सुनेंगे। अभी तक तो ये बात हो ही नहीं रही है क्योंकि निचली अदालत ने उन्हें कन्विक्ट कर दिया है और हाई कोर्ट में अपील पड़ी हुई थी। 8 साल की सजा ऑलरेडी कुलदीप सेंगर काट चुके हैं, लेकिन अभी तक ये तय नहीं हुआ है, ये अपील अभी हियरिंग चलनी है हाई कोर्ट में और सुप्रीम कोर्ट में कि वाकई में कुलदीप सेंगर बलात्कारी है या नहीं है। ये सबसे महत्वपूर्ण विषय है। अभी तो टेक्निकलिटीज पर चर्चा चल रही है कि सजा जो मिली किस ग्राउंड पर मिली, कैसे मिली, वो ग्राउंड, अब वो ग्राउंड सही है कि नहीं? अगर वो ग्राउंड सही नहीं है तो जो सजा मिली है वो भी गलत होगी और जिसने सजा दिलवाई है वो भी फंसेंगे। ये महत्वपूर्ण है। इसलिए अपील अदालत में ये होगी कि कुलदीप सेंगर ने बलात्कार किया है या नहीं किया है। हमारी नजर उस पर है। आपने ये पूरी बातचीत आपने देख ली, पूरा लाइव डिस्कशन आपने देखा। हम पहली बार ये सुप्रीम कोर्ट का ये लाइव डिसीजन, लाइव बहस आपके सामने लेकर आएंगे। कल इस मामले में और विस्तार से कुछ फैक्ट के साथ हाजिर होंगे। बहुत बहुत शुक्रिया। नमस्कार।